Well, tomorrow the Supreme Court will hear a historic case, the Dobbs case that comes out of Mississippi. That case strikes at the very heart of the conversation about Roe v. Wade that we've had as a nation for the last 48 years. That is, can a state protect the life of a child before it is considered viable? In 1973, when the Roe v. Wade decision was made, they created the viability standard out of whole cloth. There was no standard in law to be able to do that. When they created this viability standard, courts have struggled to be able to actually interpret that and apply it since that time period 48 years ago. I remind this court, and I remind us as a nation, 52 years after the Plessy versus Ferguson decision from the Supreme Court, when the Supreme Court determined that separate but equal was entirely appropriate in American law. 52 years later, the court determined it wanted to be able to hear the Plessy versus Ferguson decision again. And it took up what was then called Brown versus Board of Education. The Brown versus Board of Education, 52 years later, after Plessy versus Ferguson, re-looked at this issue of separate but equal and determined how in the world did we ever decide that as a court. And Plessy versus Ferguson is still recognized today as one of the worst court decisions ever done, 52 years after it was first decided. Roe v. Wade is 48 years old. I believe this court will take up the legal argument, will take up the scientific examination, and will re-look at Roe v. Wade in a whole new way, and will return this country to what it was pre-1973, where each state made their own decisions to be able to protect the lives of every single child. This group of people that are gathered around are in strong support of that. I'm going to allow them to be able to step forward and to be able to speak into this issue as well as we anticipate the 10 a.m. oral arguments in the Supreme Court tomorrow morning. Senator Daines.